So where do you think that we are in terms of this movement? I mean, you do a great job of explaining, I mean, basically a 40-plus year, I mean, centuries long, but especially the last 30 or 40 years of people organizing and building an intellectual movement and a political movement around the idea of corporate rights, and the need to push back and create some sort of similar movement against that. Where do you think we are now, up 2 years after Citizens United? Are you starting to see that kind of mobilization, and what are some of the chinks in the armor that you're seeing around Citizens United?
It's a great question, Mark, because in my view, this idea of corporate personhood and responding to this corporate rights campaign, frankly, it's a little bit like finding yourself at a cocktail party with bell bottoms and everybody else has moved on. It was not a fashionable thing to do, and it was not a mainstream idea, and it was not a big issue in the law schools. It's not a big issue on the courts. If you were fighting the sort of idea that corporations have rights under our Constitution rather than rights under our statutes that we decide upon, you didn't have a whole lot of company. And I think what Citizens United has done is it's been the wake-up call that this isn't fringe. It actually is a traditional American approach to democracy. The corporate power is always a problem. They're really great vehicles for economic activity, for marshaling investment, for spreading risk, spreading reward, all kinds of great things. But there's a danger, as Justice Rehnquist said, as Madison said, as Theodore Roosevelt said, as the court has said in past years, is a danger that they will try to leverage that into political power and can corrupt and, like Madison's faction, ultimately destroy democracy if we don't keep them in balance. And so Citizens United, and now especially after 2 years of living under Citizens United, it's been illustrated for people across the country exactly how it happens, especially in elections. And so it is no longer sort of the bell-bottom wearing crowd. It's again, as it has been before, a mainstream American problem that we will come up with a mainstream, and I say that meaning conservatives, progressives, liberals, libertarians. The hostility and opposition to Citizens United crosses all of those political lines. Support for the constitutional amendment crosses all of those lines. And so where we are is much further than I would have expected 2 years ago, partly because the raw exercise of this new power under Citizens United has been so compelling and quick. I don't know if you saw the Times front page story after the Super PAC reports came in. I think it was yesterday's paper, where there's a lot of corporations spending the money. As Michael said, the idea that they won't is just not true. There's millions and millions of dollars of corporate money pouring in. Some of the corporations, we have no idea what they are. They're a post office box with no employees, which is a problem in itself. Others are like Alpha Natural Resources, a giant coal company pouring millions of dollars in. They own Massey Energy Corporation, which Free Speech for People actually has a campaign to revoke the Massey corporate charter because of their has been called industrial homicide of 29 workers in West Virginia. And I don't think there will be any consequence except positive for Alpha Natural Resources, which says something about, in my view, about disclosure as a remedy, that it's not something that can just be tolerated and disclosed, because I think it actually serves them well. In some ways, it's like the chamber saying publicly, right up on their website, we are a $200 million a year lobbying political powerhouse, and the president of the chamber, Tom Donahue, saying, when we bite you in the butt, you bleed. They want to know. They want politicians to know that they're doing this. And so where we are is, I can go into a lot more detail specifically about where we are, but there are millions of Americans who've signed resolutions to reverse the Citizens United decision. Just a few days ago, the New Mexico House of Representatives voted to call on Congress to amend the Constitution, send the amendment to the states for ratification, to overturn Citizens United. New York City, right here, has passed that resolution. Los Angeles, towns and cities across the country. The Montana Supreme Court famously has decided the Montana Corrupt Practices Act banning corporate money in elections still stands despite Citizens United, showing really almost across the board why Justice Kennedy was so wrong as a matter of fact and law about the corrupting effect of corporate spending in elections, about disclosure, shareholder control, all of those things. So we're seeing this movement really in all sorts of different forms, and it's not, again, the bell-bottom wearers, it's Supreme Court justices in Montana, it's Second Circuit justices, judges, it's, you know, it's people who aren't necessarily lawyers but know that this is fundamentally wrong, our country's on the line, and we need to fix it.
Hi, so I'm Tony Butler. I'm the Chief Operating Officer here at Brennan Center, which is I want to broadcast right away. I'm not a lawyer. So this may be a bit of a naive question in a room that I guess is predominated by lawyers, but like, how did this happen, right? You're very clear, it seems to me, that it seems nonsensical on its face to a non-lawyer to say a corporation is not a person. So what exactly, how did the Supreme Court convince itself that a corporation has those rights? How did this battle get won that we are now on the defensive on what seems to be, on its face, a very illogical proposition?
Yeah. Great question, thank you. And the shortest answer is read the book.
No.
Which is really what the book is exactly all about. And the slightly longer answer is, as I said, in my view, this is a struggle that has always, is part of being American almost, that back in the early days, that Andrew Jackson fought about the Bank of America the idea of incorporation because of the concern about corrupting influence back in the early 1800s. The framers were worried about if we give limited liability and these advantages, it's going to corrupt our government process, and they had things like 20-year limits on corporate charters so that they would not get out of hand. They'd have to come back to the public and explain what good they did for the public before they get a new corporate charter. And then, of course, the famous Santa Clara line of cases in the last Gilded Age, late 1800s, saying after the Due Process Clause, after the Civil War and the 14th Amendment, guaranteed equal protection and due process to all persons, essentially regardless of race. It was the famous, essentially healing amendments after our Civil War, intended to protect all people. The railroad corporations drove into the law with just relentless perseverance the idea that corporations were persons too and had equal protection rights and due process rights. Eventually the court waved the towel and said, okay, I guess they do, they keep saying it. And the problem is, under state law, when the idea of a corporation, the person metaphor is actually very useful. It's what enables a whole lot of people to get together and act as one in a business, for example. The president signs a contract, president of the corporation. It's going to be binding even if the president goes and someone else is there. It doesn't matter. It's the corporate person that has made that contract. We can sue and be sued, or we can enforce the law when the Clean Water Act says no person shall dump pollutants into the waters of the United States. That includes a corporation. So all those are good metaphors, but notice every one of those are metaphor. It's a person definition that comes out of state law that we decide on in a democratic fashion and could change if we didn't want to. It might be really inconvenient. I don't think it's a good idea, but you could say corporations are not a person under state law, and you have to go and name all the shareholders individually if you want to sue them. It's a bad idea. The problem is that the word person in the Due Process Clause and Equal Protection Clause and people in the Constitution was never intended to do that. So they kind of took a state definition of person under state law and just used that to drive that theme into their briefs. And as I said, we won that fight. That's, again, part of the process is always that push back and forth, I think, between people and sort of unchecked, unbalanced corporate power. Then the new version of that corporate personhood, as I said, came out of this corporate speech idea that Lewis Powell came up with. And so you'll hear sometimes, Citizens United never says corporations are people. Citizens United doesn't use corporate person. That's sort of true technically. Citizens United did not say corporations are people too. Therefore, what the trick has been to say, to not define corporations, to really pretend you're talking about people and then just go forward. So the court uses in Citizens United, Justice Kennedy's opinion, says Congress can't make laws that benefit some speakers but not others, that squelch some voices, that he talks about that the law is unconstitutional where it disadvantages a class of person. Actually says a disadvantaged class of person, referring to the corporations. And that comes right out of the law that struck down the Bilotti case I mentioned. Monsanto won a case that struck down a Vermont law that required disclosure when they use genetically modified bovine growth drugs. We don't have disclosure laws about that, even though this is a drug that's banned in every democracy in the world. We're not even allowed to require that we know about it. That was considered a violation of the corporate right not to speak. So they developed, and you read the amicus briefs that the Chamber of Commerce and Washington Legal Foundation and all these entities that were set up, the National Chambers Litigation Center, set up in response to the Powell memo, and they're driving this theme: corporations are people, corporations are persons, corporations are speakers, and they say it right there. So there's no question. In the Powell internal documents I talked about in the Bilotti case and others, he's saying corporate rights. So the notion that Citizens United is just about when people are speaking and they're using corporate entities, that's not what's happening. They really are using a corporate person metaphor, and they're misusing it because they're taking what is a useful metaphor under state law for corporate activities that we can decide on as a majority, and twisting it into person when it's used in the Constitution as who has rights, which aren't, we don't vote on who gets rights under the Constitution. They're there because we're human, and we have rights. We're born with the rights, and so when the Constitution says persons, it's not something that we can just invent under state law. And so that, in my view, how it happened is an abuse of language, an ideologically driven abuse of language.
So 5 justices bought the ideology, is that?
Yeah, eventually 5 justices were persuaded by the relentless, organized, very well-funded campaign. And we sort of forgot that, hold it, corporations, they're entities that we create. We should decide on the rules for them.